But a lot of people are wondering what happens if you've already been let go, if you've already been terminated, you no longer have a job, or you've resigned. But now you're like, hey, maybe I got hurt at work. I want to file a workers' compensation claim. Alex, can you file a claim if you've been fired, if you've been let go, or if you've resigned?
Yes, of course, you can always file a claim for workers' compensation benefits. But can the employer deny the claim if you file it after the employer's giving you notice of termination or layoff? That's what a lot of people have questions about. Hey, my employer has given me a notice that they're going to terminate me or lay me off, and now, I've been hurt and I never filed that claim. Yes, you can file it, but the employer has a defense, and that is the post-termination defense.
Right.
And basically what that means is the employer says, hey, you didn't tell anybody, you have no evidence of being injured, and now suddenly we give you a notice of termination, or we tell you that we're going to be laying you off, and all of a sudden this injury pops up. It's inherently suspect. So the law gives the employer and their insurance company a defense if the injury is reported after. This is episode number 24 of the Inland Empire Workers' Compensation Lawyer live stream podcast. My name is attorney Alexander Napolin. I'm joined by attorney George Abuado every Sunday at 3 p.m. to discuss a new topic in workers' compensation law and employee rights. Remember that the discussions that George and I have are general in nature only. They're meant to help you, but they're not legal advice. If you're looking for legal advice, you need to dial our injury helpline at 844-984-8414.
99% of the times, they can deny the claim, and they will. You know, we all know insurance companies don't like to pay out money. That's the least the least favorite thing that they like to do. Their favorite thing is to deny a claim. So we go from spectrum to spectrum. They love denying claims. They don't like paying out money, right? So they're going to find any reason to deny your claim. Now, what Alex was talking about, the affirmative defense of post-termination, which means that you no longer work there, now you're bringing forth a claim, that's a very strong defense for them. Because what they're going to say is, listen, while this person was working here, he had a chance to report his injuries. He had a chance to get medical treatment. That's the way it's supposed to work. But now that he's been terminated, now that he's been let go, now why is he bringing forth this claim? It's not as believable. Now it might be because of several different reasons. Maybe you're upset that you got fired. Maybe you just don't like the company. These things come about, and the insurance company points to those things and says, they just want to get back at us. It's not a legitimate claim. And because of that, we're bringing forth the post-termination defense and we're denying the claim. And once again, we've talked about this. They deny the claim for a lot of reasons. This is a very specific reason that is very effective. The good thing about this is that you have a defense, or can go on the offensive and say, wait a minute, I might have put in a claim after I was terminated, but I have these other things that show that I did get hurt at work. And we're going to talk about that. The first thing, Alex, that you can show that you were hurt at work is even if you didn't report a claim or get medical treatment through your employer, maybe you went to your personal doctor and said, hey, doctor, my back, my shoulder, my leg, whatever the body part, something is hurting, and I think it's because of work. If you obtained medical treatment while you were working with your own personal doctor or otherwise, even if it's not through the company or through the insurance company for a workers' compensation claim, you can point to that and say, listen, I was working there. I had problems. I went and sought my own treatment, but it was because of work. Right, Alex? You ever get those?
Yeah, of course. If you have medical evidence, you've been to the doctor, that's what you're talking about, right? And you have that to back yourself up. That's going to defeat the post-termination defense.
Right.
And that extends potentially to other body parts that were not reported to your doctor. Like,
right.
Let's say you went to the doctor and said, hey, I fell, I had an injury, I hurt my back. And then the next day your employer says to you, hey, you're terminated. Well, if you can produce those doctor's reports, that's going to help you prove that, hey, this isn't one of those situations where, like, as you mentioned, I'm the injured workers just reporting the claim because they were terminated or for some other reason. No, right. It was because of some legitimate fall that occurred that can be shown with medical evidence. Medical evidence that's obtained prior to the notice of termination or layoff, though.
Right. And this brings us into an area, and we'll just do a little sidebar about this, fraud. Okay, so what they're claiming in not so many words and not using the word fraud and not being that extreme is saying, maybe this is not a legitimate injury, right? They're saying you weren't really injured at work. Now, fraud is completely different because you know you weren't injured at work and you're bringing in a fraudulent claim. Completely different, but it's along the same lines in that it's not a legitimate injury that occurred at work. And that's the way they're trying to get off from paying whatever they owe you. So if you can prove that, in fact, you were hurt at work, that defeats their defense. But Alex, before we go on to maybe using different things to defeat that defense, what does the employer have to prove in order to bring forth this defense of post-termination?
The employer has to prove that the reporting was done after the notice of termination or layoff, and that the injury occurred prior to the notice of termination or layoff. So, for example, if your employer says, "Hey, you're terminated, but it's going to be next week, and you have some time, and then you get hurt after that," that is not subject to the defense. So that the employer cannot use the defense if the injury happens subsequent to the notice of termination or layoff.
What's another way that you can defeat this post-termination defense? You would use something like MedLegal. Go to a qualified medical examiner. Once you go to them, they have to give their expert opinion. So I find a lot of my cases, they are post-term. We take in those people that need help and that we know we can help. So even if it's not going to be an easy case, we help them out. We talk to them and see what we can do for them. If we feel that we can move forward with that case, and definitely we take them in. But let's say I have a client, it's a post-termination defense. I know I'm already going to get a denial letter in the mail, especially if they don't work there anymore and we just filed the claim. So the first thing I do is seek medical treatment for them. If it's denied, of course, they have to go and treat outside the medical provider network, and we get them a doctor on a lean basis. But what that does is it starts establishing some medical reporting, right? And if you get them a good doctor and they explain their situation and how they were hurt, how they're injured, the doctor's going to do what we call an examination of their medical history, of the history and mechanism of the injury, and they're going to see if the injured body parts correlate to that mechanism of injury, right? And that's going to be included in the report. It's going to be really good for you if you have a good doctor to talk to them and let them know, "Doctor, this is how long I've been working there. These are the job duties I had to do, and this is why I'm injured." That's going to come into the report. It's going to be really helpful in proving your claim. After that, you do have the right to go to a neutral doctor, which is a qualified medical examiner. We've discussed this again. Check out our videos. Who's going to give you a full evaluation of your claim, a full evaluation of your body, a full evaluation of the medical reports that are out, and even the ones that may have existed prior to that for those body parts. And they'll give their opinion. Within their opinion, they have to talk about causation, okay? And causation is, how did you get hurt? And causation, for our purposes, is either industrial or non-industrial. If it's industrial, it means you were hurt at work. If it's non-industrial, it means that you were not hurt at work. There is some leverage. I mean, there is some room to play with where they say they might have gotten hurt at work and it was 80% because of work, 20% because of something else. That's called apportionment. Either way, they have to comment on whether you were hurt at work or not. It's a very important evaluation, and it's very important that we get a good report so we can use that in order to prove that you were injured on the job.
Right, and I think that kind of goes to a cumulative trauma injury. So it may be that you didn't have a specific date of injury. So what we're discussing here is just not applicable to your situation. You have what we call a cumulative trauma, which means that you're injured over time from repetitive work activities. So if you have that type of injury, it may be that the date of injury for purposes of this rule is actually after the date of your notice of termination or layoff. And that can be established by a QME.
Right.
For example, you might not have missed any work at all because of your carpal tunnel. You just continued to work through it. So you've had no disability. So therefore, when the QME, the qualified medical evaluator who looks at all of your medical records, looks at you as a person, does a physical examination, and then comments upon how that injury took place, they might say, yes, you have a cumulative trauma, repetitive work activities claim, and also I'm telling you about that for the first time, and therefore you're getting knowledge of it, injured worker, and you haven't missed any work until after the termination or layoff, so your date of injury is actually afterwards.
Right.
And that can get around the defense and defeat the defense that the insurance company is putting forward. So just because you didn't report your injury, or just because you've been let go doesn't mean you shouldn't file a claim. The answer is yes, you can file a claim. You should file a claim, and you should dial the injury helpline if you have any questions, 844-984-8414, because you need a lawyer to look at this stuff. You can't just listen to our video and then decide what to do. This is general information that's meant to help you, but it's not legal advice. You listen to the video, you listen to the discussion that George and I put together, and then you start to have questions and you start to wonder, do I have rights? And the answer is probably yes, you do. And you should speak to a lawyer about them.